we shall be discussing constitutionalism. 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 Now, the first point of call is to make it clear that constitutionalism is not the same as government by a constitution. As a matter of fact, you can even have a government that has a constitution but will not have constitutionalism in that particular legal system. Again, constitutionalism is not the same as government governing according to democratic principles. Democracy is different from constitutionalism. So the question is, what then is constitutionalism? If we are saying constitutionalism is not the same as democracy, and it's also not the same as government being governed by the constitution, then what is constitutionalism? I refer to authoritative statements about constitutionalism by two scholars. The first is Sir Kofi Kumadu in his book, A Handbook of the Constitutional Law of Ghana and its History, first edition, page 15. And this is what the learned author says. And I'm quoting. Constitutionalism means government according to predetermined rules, which restrain or limit governmental activity. These include the existence of rules prior to governmental action and not ruled by personal fiat. These rules must be designed to effectively restrain or put brakes on governmental activity. The restraints may be institutional, procedural, or substantive. For constitutionalism to prevail, the rules putting the restraints on governmental activity must be made legal. That is a mechanism which should be provided in the Constitution for policing them. Then the quote ends. Again, I refer to Sir Kofi Kumadu once again in his article, Constitutionalism, Civil Liberties, and Development. This has been published in the University of Ghana Law Journal, 1980. And this is what the learned author says in his seminal article. And I quote, "The key concern of constitutionalism is the division of governmental power in such a way that there is an effective restraint on the arbitrariness inherent in power, so that the individual, society, will be the beneficiary. Such a system of restraints may be embodied partly in a written document and partly left to be enforced by the force of tradition. But it is important that these restraints be legal, that the government so restrained be under law, and that these restraints be enforceable before an independent body of arbiters in the event of a claim by an individual of their violation. Separation of powers, rule of law, judicial review, to mention only a few of the key ideas which constitutes the constitutional lawyer's merchandise, are only a breakdown into smaller proportions of the basic idea of constitutionalism. Quote ends. Finally, I would refer to the words of Carl Friedrich, Fredrich, in his book, Constitutional Government and Democracy. And this is what he also says, and I quote, and he's referring to constitutionalism, I'm quoting, "It embodies the simple proposition that the government is a set of activities organized by and operated on behalf of the people, but subject to a series of restraints which attempt to ensure that the power which is needed for such government is not abused by those who are called upon to do the governing." Quote ends. Now, what is common in all these three definitions by Sir Kofi Komado and Carl Friedrich? You realize that in all the definitions, the focus is that there must be some restraints, some limitations placed on the exercise of governmental power. So all the three definitions are all to the effect that before governmental power is exercised, there must be some restraints or limitations placed on the exercise of governmental power. In other words, there must be some predetermined rules that will restrain or limit governmental powers. That is what we mean by constitutionalism. If constitutionalism is government according to predetermined limitations or restraints, our next question will be, how should these restraints be made effective? How should the restraints be made effective? The first thing to point out is that the existence of a written constitution, it becomes very relevant and important because when you have a written constitution, when you have a constitution that is written, that document may set out the limits and the restraints that is supposed to be placed on the government. This point has been made by Chief Justice Marshall in the famous US Supreme Court case of Marbury and Madison, where the learned Chief Justice Marshall mentioned that placing of the limitations on governments in the written constitution is essential for us to know what the limits of those governments are, so that if they embark on excursions outside the limits, they can be easily checked. Permit me to quote the express words of Chief Justice Marshall. This is what he says in Marbury and Madison: that the powers of the legislature are defined and limited, and as those limits may not be mistaken or forgotten, the Constitution is written. The quote ends. Again, the powers of the legislature are defined and limited, and as those limits may not be mistaken or forgotten, the Constitution is written. Quote ends. Therefore, if we are saying constitutionalism is government according to predetermined limitations, how can we make these restraints effective? The first means of making them effective is to write them down, is to have a written constitution. Because as Chief Justice Marshall has said, if you write those limitations down, then we prevent people from forgetting them or getting them mistaken. And then that is why we say that, so that if people now go beyond the limits, they can be checked. So we are saying there must always be predetermined limitations on the exercise of governmental power. And in answering the question as to how we can make these restraints effective, we have noted that one key means is by ensuring that these limits are defined in a written law. And we have referred to the words of Chief Justice Marshall so that we prevent people from forgetting these limits, so that when they go beyond the limits, we can check them. It must be mentioned at this point that in order to make the restraints effective, there are some countries that leave this role into the hands of the judiciary, an independent judiciary. That will be the judiciary, will be the ones that will make sure that people don't go beyond the four corners and the confines of the limits that have been confined on them by the Constitution. But it must be mentioned that there is no uniformity in practice about whether this act of checking the restraints, there's no uniformity in practice about whether it should be the role of the judiciary or it should be the role of the legislature or it should be the role of the executive, or we should even leave them to determine it for themselves. There's no uniformity in practice. In some jurisdictions, you will see them placing this more into the hands of the judiciary, which is actually very, very effective. And one of the means of ensuring that the powers of government are limited. To demonstrate that if you have an independent judiciary, which is immune from control of the executive and the legislature, that judiciary can serve as an effective means of placing restraints on the exercise of governmental power. But do not get me wrong. I'm not saying that it is only the judiciary that has a role to ensure that limits are placed on the exercise of governmental power. In Professor Komado's article, he says, and I quote, that there is, however, no uniformity in practice about whether the policing of the Constitution should be performed by the judiciary or simply by hoping that the organs of government will restrain themselves and keep within the boundaries of their constitutional powers. Perhaps the boldest one can get in this area is to assert that some countries rely on the judiciary as well as the legislature to keep the boundaries of governmental power undisturbed, while others leave everything entirely to the good sense of legislators. I'll take the quote once again, and I'm quoting from Sir Kofi Komado's article titled Constitutionalism, Civil Liberties and Development, published in the 1980 University of Ghana Law Journal. This is what he says, and I'm quoting once again. There is, however, no uniformity in practice about whether the policing of the Constitution should be performed by the judiciary or simply by hoping that the organs of government will restrain themselves and keep within the boundaries of their constitutional powers. Perhaps the boldest one can get in this area is to assert that some countries rely on the judiciary as well as the legislature to keep the boundaries of governmental power undisturbed, while others leave everything entirely to the good sense of legislators. Quote ends. So that's why we are saying that as far as constitutionalism is concerned, we are talking about predetermined limitations on governmental power. And these predetermined limitations on governmental power, for these restraints to be effective, we have mentioned that one of the means is to have a written constitution Because as Chief Justice Marshall has said in Marbury and Madison, it is when you have limitations written in the Constitution that is what makes people from forgetting to go beyond the limits. Another means of ensuring that people stay within the boundaries of their limits is when you have an independent judiciary. Because that independent judiciary are the ones that will hold the executive and the legislature in check when they are going beyond their functions and the limits of their powers. But we have been quick to mention that it is not a matter of uniformity among countries. That when it comes to how we will ensure that people stay within their limits, we give everything to the judiciary. Because as we have seen in the article I just read, some countries may decide to leave the power of policing the Constitution or checking the restraints. Some countries may leave that power for the judiciary. Others may leave it for the judiciary and then the executive, judiciary and the legislature. So we are only looking at means of making these restraints effective. And we have mentioned that one means of making it effective is by a written constitution, and the other means is also by having an independent judiciary. But I'm only cautioning you to say that, do not get me wrong in saying that every country must necessarily use these restraints. Again, when we move ahead, you realize that in Ghana, in our constitutional framework, we have given roles to the judiciary to perform to ensure that we have constitutionalism. We have given some roles to Parliament to perform to ensure that we have constitutionalism. We have given some roles to the executive to perform. So do not get me wrong and think that it is only the judiciary that has a role to play in ensuring that the restraints placed on governmental power are effective. It is not only the judiciary, but the judiciary is a key institution that will play a role in ensuring that we achieve constitutionalism. Having gotten to this point, I can now explain to you why we say that constitutionalism is not the same as government according to a constitution. Because now you know that constitutionalism rather refers to the limits or the restraints placed on governmental power. So if you have a written constitution, you have a democratic government, but that constitution gives the government so much unlimited power, they can pass laws to abuse people's fundamental human rights, then you know that that government, even though they have a constitution, the government has been given so much unlimited power and is abusing people's rights. And in that instance, you can say that we do not have constitutionalism in that system because there are no restraints placed on the exercise of that governmental power. So far, we know two means so far that we can adopt to ensure that the restraints placed on these governmental powers are effective. One mechanism we can use to make the restraints effective is to have a written constitution. Another mechanism we can use to ensure that the restraints are effective is to have an independent judiciary. Again, when you read Sir Kofi Komado's article titled Constitutionalism, Civil Liberties and Development, this is what he says, and I quote, "Separation of powers, rule of law, judicial review, to mention only a few of the key ideas which constitute the constitutional lawyer's merchandise, are only a breakdown into smaller proportions of the basic idea of constitutionalism." Quote ends. So it means that in addition to having a written constitution, in addition to having judicial independence, separation of powers, rule of law, judicial review, when you see these things manifested in a particular system, they all constitute element of constitutionalism, because separation of powers is a mechanism we can use to ensure that there are restraints, the restraints placed on the exercise of governmental power are effective. Because if you have separation of powers, you would prevent the situation whereby one single person will have the power of making laws, he has the power of interpreting the laws, he has the power of implementing them. When that happens, then that power can be abused. So, separation of powers is also another means that we can use to give strength to the restraints placed on governmental power in order to achieve constitutionalism. Rule of law, that the law is supreme. Everybody must be subject to the rules of law. There must be equality of the law. This is another means that if it is applicable in the legal system, it is going to help us achieve constitutionalism, because it would ensure that the restraints placed on governmental power are effective. And then we have judicial review. Judicial review of the courts. Let's say judicial review of the court to declare an enactment passed by Parliament as unconstitutional. It means that when Parliament goes ahead to pass a law which is repugnant to the Constitution, who is going to check Parliament to ensure that they don't go beyond the bounds of their limits? The power of judicial review will ensure that the Supreme Court can declare such activities as unconstitutional. It means they are whipping the legislature back in line so that they will stay within their limits. It means judicial review is also another mechanism we can use to strengthen the restraints placed on governmental power. So if you have a question and they ask you, what are the elements of constitutionalism? Or by what means can we achieve constitutionalism? Elements. Having a written constitution is one. Judicial independence is one. Separation of powers is one. Rule of law is one. Judicial review is also one. Because these are all mechanisms we can use to ensure that the restraints placed on governmental power are effective. Not only this, there must also be the respect for fundamental human rights. If you have a country and people, you're not respecting people's fundamental human rights, then it means that there's no limits placed on the people exercising governmental power. And so we do not have constitutionalism over there. In Sir Kofi Kumado's book, titled A Handbook of the Constitutional Law of Ghana and Its History, the first edition, page 17, this is what he says, and I'm quoting. First, for constitutionalism to prevail, the Constitution must guarantee, not grant, the rights of the people against government and their fellow citizens. These rights must be justiciable. There must especially be freedom of political activity, freedom of speech and expression, including the right to debate public issues, free media, the right to assemble, protest and petition the government, equality and equal protection under the law, and non-discrimination. Human rights constitutes the single most important limit to governmental power. Second, there must be acceptance among the generality of a populace that the exercise of governmental power must be subject to limits. The absence of this general acceptance would render paper limitations nothing but a blank check. On the other hand, where this acceptance is embodied in the public ethos, the grant of public power, which appears on the surface to be limitless, will in practice be subjected to effective limitations. Then the quote ends. So he recognizes that for constitutionalism to prevail, the Constitution must guarantee the rights of people. So respect for fundamental human rights is also an element of constitutionalism. Note that the Constitution must guarantee the human rights, and the rights must be justiciable. They must be enforceable in courts of law. There must be freedom of speech. Freedom of speech will ensure that governmental power, there are restraints on it. Because if you go beyond the power, then we can have people that will come and criticize you and whip you back in line. Then he makes a very interesting point, that if you have all these limitations on paper, but the people do not feel that they must go by these limitations, then there will just be paper limitations. So Sir Kofi Komado recognizes that, and he mentions that we must have acceptance among the generality of the populace that the exercise of governmental power must be subject to limits. This way, people will know that they must stay within the confines of the law. So what we have discussed so far is to mention ways in which constitutionalism, the restraints placed on governmental power, we have identified ways in which we can have effective restraints. And as mentioned earlier, Sir Kofi Komando's book cites that these restraints placed on governmental power, they may be institutional, they may be procedural, and they may be substantive. They may be institutional, they may be procedural, or they may be substantive. Now, what we have discussed so far is to set the framework of the theoretical basis for constitutionalism. We have defined it according to the scholars. We have mentioned that constitutionalism is not synonymous to government by a constitution. So what it means is that even in the military regime, you can still have constitutionalism. Because if you have a military regime and then there are restraints placed on governmental power, if it's a military regime and then before governmental power is exercised, there are restraints and limitations, that there's an independent judiciary in the military regime, that there is respect of fundamental human rights in the military regime, that there is a rule of law in the military regime, that the military regime recognizes separation of powers, then in that military regime, we will have constitutionalism, because before governmental power are exercised, there will be some restraints, meaning it's not anything at all that they can do. So remember that constitutionalism deals with the restraints placed on the exercise of governmental power. Now, let us go ahead and discuss and find out how these limitations have played out in the case law. So I will examine them under the three different headings of the limitations. You remember, it has been mentioned. Sir Kofi Komando's book recognizes that there can be, the limitations can either be institutional, they may be procedural, they may be substantive. So I'll go ahead and discuss these limitations under institutional limitations, under procedural limitations, and under substantive limitations. We shall begin with the procedural limitations. Procedural limitations, or procedural breaks in governmental power, procedural limitations. Now, for the procedural limitation, we are saying that before governmental power is exercised, there is a laid-down procedure that has to be complied with. That should serve as a break or a check on governmental power. So, for example, if you look at Article 78 of the 1992 Constitution, it says that ministers of state shall be appointed by the president with the prior approval of parliament from among members of parliament, all persons qualified to be elected as members of parliament, except that the majority of members of ministers of state shall be appointed from among members of parliament. Now, my focus here is ministers of state shall be appointed by the president with the prior approval of parliament. There is a laid down procedure. So you can't say that as a president, you appoint your minister to serve you without any check, without any limitation. The limitation here, the procedural limitation here is that you must seek the prior approval of parliament. This is a check, a break, a procedural break in the legal, in the government machinery to prevent power from being concentrated in one person's hands. Then look at Article 106 clause 3. Article 106 clause 3 says that a bill affecting the institution of chieftaincy shall not be introduced in parliament without the prior reference to the National House of Chiefs. A bill affecting the institution of chieftaincy shall not be introduced in parliament without prior reference to the National House of Chiefs. What is this saying? This is a predetermined procedure, so that even though you can come and do what you want, but you cannot just introduce a bill affecting chieftaincy unless there has been a prior reference to the National House of Chiefs. It means that even though Parliament has been given legislative power, there is a predetermined procedure, there's a predetermined limitation, there's a predetermined restraint on how they can pass laws that affect chieftaincy. And over here, you can make reference to the case of Wari and Oforiata. Wari and Oforiata, 1959, Ghana Law Report 181 to 187, High Court Kumasi. Then look at Article 144. That deals with appointment of the Chief Justice. Article 144 says that the Chief Justice shall be appointed by the President, acting in consultation with the Council of States and with the approval of Parliament. Look at the laid down procedure. Acting in consultation with the Council of States and with the approval of Parliament. This is the laid down procedure. You must comply with this procedure. You can't wake up one day and you say you've appointed a CJ when nobody knows about it. No, we want to prevent that abuse. So even though the president is given the power to appoint, if he appoints somebody, that person must have been approved by Parliament. So that if Parliament does not approve of the appointment, that is serving as a check on whoever you appoint as the Chief Justice, a procedural limitation. Now, when you appoint and the person is not doing your bidding, can you wake up and just say that you want to remove the person from there in any way that you so wish? The procedure for removal is also there. Article 146. Article 146. If you read Article 146, it will tell you that if you want to remove a justice of the Superior Court, then first of all, there must be a petition sent to the president for the removal of that Superior Court judge. And then when that petition has been received, then the president must refer it to the Chief Justice. When the president refers it to the Chief Justice shall now have to determine whether there's a prima facie case. If the Chief Justice determines that there's a prima facie case, then he shall then set up a committee. The committee shall consist of 3 justices of the Superior Courts or chairman of the regional tribunals or both. And they shall be appointed by the Judicial Council and 2 other persons who are not members of the Council of States, nor members of Parliament, nor lawyers, and who shall be appointed by the Chief Justice on the advice of the Judicial Council, of the Council of States, sorry. So look at the procedure. Before you remove the Superior Court Justice, there must be a petition given to the president. The president will have to forward it to the Chief Justice. The Chief Justice will have to establish that there's a prima facie case, when he establishes that there's a prima facie case, he has now formed the committee. Look at the procedure. It means that this is a prior and predetermined limitation. It's a predetermined procedural limitation on how you can exercise governmental power. So it is important for you to note that internal in our Constitution of Ghana, we have laid down some limitations in order to serve as brakes on governmental power. On governmental power. Again, beyond procedural limitations, we can also look at substantive limitations. Substantive limitations. These substantive limitations, they are real or actual limitations. And they are placed on the exercise of legal powers by substantive laws of the state. What you notice about them is that they normally come in the form of prohibitions to say that you can't do this, or they may come in the form of mandatory injunctions that you must do this. So when we say they come in the form of prohibitions, let us look at some examples under the Constitution. Article 3, Clause 1 of the Constitution. What does Article 3, Clause 1 say? Article 3, Clause 1 says that Parliament shall have no power to enact a law establishing a one-party state. This is an absolute prohibition. It's a predetermined absolute restraint. It's a predetermined absolute limitation on the exercise of governmental power. So no matter what you come and do, if you come to power and you have a parliament, you shall have no power to enact a law to make Ghana a one-party state. This is an absolute prohibition, and it falls under what we call substantive limitations. Take a look at Article 1, Clause 2 of the Constitution. It says, the Constitution shall be the supreme law of the land of Ghana, and any other law found to be inconsistent with any provision of the Constitution should, to the extent of the inconsistency, be void. What does it mean? It means that anytime you have a constitution and you have any law that turns out to be inconsistent, it has been predetermined that that law which is found to be inconsistent, it shall be void. In other words, nobody has a power to pass any law that will be inconsistent with any provision of the Constitution. So you see, it also comes in the form of a prohibition. And then Article 107 of the Constitution, what does it say? The Parliament shall have no power to pass any law. A, to alter the decision or judgment of any court as between the parties subject to that decision or judgment. So if you go to court and I go to court with you and the court grants judgment in my favor, Parliament cannot pass any law that will have the effect of altering the decision or judgment of that court as between we, the right of the parties to that suit. This is an absolute prohibition. Parliament, you can't do it. It's a substantive limitation. And it is in the form of a prohibition, telling you what Parliament cannot do. Again, still under Article 107B, it says that Parliament shall have no power to pass any law which operates retrospectively to impose any limitations or adversely affects the rights and liberties of any person, or impose a burden, obligation, or liability on any person, except in the case of a law passed under Article 178 or 182 of this Constitution. And so, if it comes to Parliament passing a law that will have a retrospective effect to impose any limitation on anybody, the Article 107 says Parliament does not have that power. This is also a substantive limitation. And remember, like I said, the substantive limitations, they come in the form of prohibitions or mandatory injunctions. So far, the ones we've looked at under Article 3 Clause 1, under Article 107, all of these are in the form of prohibitions. Article 3 Clause 1, Article 107, Article 1 Clause 2. They are all in the form of what? Prohibitions. Mandatory injunction means that this one, you must do it. You must do this. So the law is placing an obligation, mandatory obligation, that you must do this. Look at Article 92, Clause 2 of the Constitution. It says, the Council of State shall also meet, if requested by the President, Parliament, or not less than 5 members of the Council. It means as soon as the President or Parliament or not less than 5 members of the Council request, they must definitely meet as Council of State. Then look at Article 58, Clause 1. It's also another form of a mandatory injunction. It says, the executive authority of Ghana shall vest in the President and shall be exercised in accordance with the provisions of the Constitution. It is mandatory. It shall be exercised in accordance with the provisions of the Constitution. Mandatory. But you must exercise it in accordance with the provisions of the Constitution. Then look at Article 67. It says the President shall, at the beginning of each session of Parliament and before a dissolution of Parliament, you shall deliver to Parliament a message on the state of the nation. It is mandatory. You shall do this at the beginning of each session and before a dissolution of Parliament. And then we also have institutional limitations. These limitations are placed on the exercise of an institution's powers by one institution. And usually this institution is serving as a limitation or a check on the other institution. So for institutional limitations, they come in the form of separation of powers and checks and balances, where one institution is serving as a check on the other institution. The perfect example you can get is Article 2 of the Constitution, which gives the judiciary the power of judicial review, so that the judiciary can declare as null and void any action by the executive or the legislature, which is found to be inconsistent with any provision of the Constitution. That is a clear institutional limitation. Again, if you remember Article 78, Parliament is given the power over there to approve of ministers appointed by the executive. It is another clear case of an institutional limitation because Parliament is serving as a check on another body. Another clear case is Article 75. When the executive enters into a treaty under Article 75, you must come and gain the ratification of Parliament. So Parliament is serving as a check on the executive. Another one is Article 181. If the President or the executive goes ahead and is going to take a loan or an international business transaction, under Article 181, Parliament says at the check, you must come and gain the prior approval of Parliament. So what we have done so far is to first define what constitutionalism is as a system of government where you have effective restraints placed on the exercise of governmental power. After defining constitutionalism, we have gone ahead to look at the means of achieving the restraints placed on governmental power. We mentioned that one means of ensuring that the effective restraints is to have a written constitution. Another means is to make sure that we have an independent judiciary. We mentioned that the respect of fundamental human rights is also another means of ensuring that there are restraints placed on the exercise of governmental power. We mentioned that separation of powers is also another means of ensuring that there are effective restraints placed on governmental power. Again, we looked at the rule of law, that it's also another means of ensuring that there are effective restraints placed on governmental power. And then we also looked at the power of the courts for judicial review, that the power of the court to review legislation by the executive or to review actions by the executive to declare same as unconstitutional. It's also another means by which we can ensure that there are effective restraints placed on the exercise of governmental power. We then took a look at the different means in which we can have these limitations. We mentioned that these limitations can come in the form of procedural limitations, they can come in the form of substantive limitations, and they can also come in the form of institutional limitations. We have mentioned so far that the substantive limitations, they come in the form of either prohibitions or mandatory injunctions. We've also mentioned that the procedural limitations would require a mandatory procedure to be exhausted before some governmental power be exercised. And then we've also looked at institutional limitations, which ensure that one institution serves as a check on the other. What we have to note at this point is that many a time you can have one form of limitation or one form of limitation that is overlapping and falling into more than one of these three limitations. So for example, Article 78 of the Constitution. Article 78 of the Constitution, we learned that it can come under the procedural limitation because it mandatorily requires a particular procedure to be exhausted in the appointment of ministers of state. That same article can fall under institutional limitation because for that same article, we have the parliament as an institution that is serving as a check on another institution, that is the executive. As a matter of fact, Article 78 can even fall under substantive limitation. Because if you look at its language very well, it has more or less been couched also in mandatory language. It is mandatorily requiring the president to appoint majority of his ministers from parliament. So that is also in the form of a mandatory injunction that you must do this. So all I'm trying to say is that we have looked at three different ways in which the limitations can arise: procedural limitation, substantive limitation, institutional limitation. But I'm saying that you can have a particular provision of the Constitution which falls under more than one of these three limitations. If you remember earlier in this lecture, we mentioned when we referred to Sir Kofi Komado's article titled Constitutionalism, Civil Liberties and Development. When we refer to that article, we mentioned that the learned author made a very strong point that there's no uniformity in practice about whether the policing of the Constitution should be performed by the judiciary or simply by hoping that the organs of the government will restrain themselves and keep within the boundaries of their constitutional powers. And we went ahead to mention that, and I quote, the boldest one can get in this area is to assess that some countries rely on the judiciary as well as the legislature to keep the boundaries of governmental power undisturbed. while others leave everything entirely to the good sense of the legislatures. So when I made this point, when I referred to this point in Sir Kofi Komado's article, I mentioned that the independent judiciary is one way and one mechanism we use to ensure that the restraints placed on governmental power are effective. But we mentioned that in some jurisdictions, we don't leave it for the judiciary alone. We also give some role to the legislature to perform, as far as ensuring that the restraints placed on governmental power are effective. Now, at this point that you now know what the situation pertains in Ghana, let me ask you, what do you think would be the institutions that are playing a critical role in ensuring that the restraints placed on governmental power are effective? In Ghana, would you say that the role has been given to the judiciary alone? Do you think the executive has a role to play? Do you think parliament has a role to play? Now, I think in Ghana, all the organs of government have a role to play. Because, for example, under Article 2 of the Constitution, the judiciary is given the power of judicial review. And under Article 2, they can review acts of the executive to declare them as unconstitutional, as we saw in the case of MPP and Attorney General 31st December case, where the judiciary declared the intended celebration of 31st December as a national holiday. It was declared as unconstitutional. In Ghana, we've also seen the judiciary limiting the powers of the legislature. We've seen that in the case of MPP and IGP. We've seen that in the case of Mensima and Attorney General. We've seen that in the case of MPP and AG, the SIBA case. In all of these cases, we've seen how the judiciary can review conduct of the legislature. Recently, we saw it in the case of Martin Tebu and Attorney General, where the court declared provisions in the Act 30 as unconstitutional. Those provisions that had created some non-bailable offenses, they declared that as unconstitutional. So therefore, it means that in Ghana, the judiciary is playing a role in reviewing executive acts and the legislative acts. But Parliament also has a role to play. Because we saw in Article 78 that Parliament is the one that will have to give the prior approval whenever the President appoints his ministers. We also saw under Article 75 and 181 that under 75, when the executive enters into treaties, for it to be binding on Ghana, we must have ratification by Parliament in accordance to Article 75. We saw under Article 181 that if the executive is going for a loan, he must gain the prior approval of Parliament. Or if he is entering into an international business transaction, he must gain the prior approval of Parliament, according to Article 181. So it means that the legislature also has a role to play in checking the executive. The executive also has a role to play in checking the legislature. For example, under Article 106, when the legislature passes a bill, before the bill will become law, it has to be assented to by the executive. Again, the executive also checks the legislature. For example, if you look at Article 71, the salaries and allowances payable to the Speaker of Parliament, those salaries shall be determined by the President. So you see that as far as Ghana is concerned, I think that we have witnessed constitutionalism pervading through the walls of the Constitution. And we've seen how we have adopted several checks and restraints placed on the governmental power, so that no matter who becomes the president, you will find it difficult to live according to your whims and caprices. You have to control to these limitations and breaks in order to prevent the abuse of power. This brings us to the end of our lecture on constitutionalism. But remember, it doesn't end over here. When you read your cases, like Shalabi and Attorney General, Look at how the court mentioned that the executive could not do whatever they want by depriving citizens of their citizenship. You will not see the word constitutionalism being mentioned in the case of Shalabi and Attorney General. But at least when you read the dictum of Hay from Benjamin, you realize that he was showing the limitations placed on the powers of the executive, of the NLC. And that even though they were powerful, they could not just take away a person's citizenship in the manner in which they so wish. So when you read it, even though you may not see constitutionalism being mentioned, whenever you see the court leaning in favor of these limitations placed on governmental power, then you should know already that it is manifesting constitutionalism. So even though we are ending our lecture here, when you read your constitution, you see things that reflect procedures that must be exhausted before executive will exercise some power, then you know we are referring to procedural limitations. And it's an aspect of constitutionalism. And it is there to ensure that a governmental power will not be abused. We'll end our lecture here for constitutionalism. Thank you.